The most common contractual mistakes. Episode 7, Not addressing events of force majeure. Part of the series, Global Business Law in 20 Minutes with Federico Vasoli. This is our topic for today.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent.
Hello and welcome. My name is Natalia. I am an advocate, mediator, and arbitrator from Warsaw, Poland.
Hello, everyone. I'm Federico Vasoli, Italian lawyer, managing partner of the MTV Global with offices in Singapore, Malta, and Vietnam. It's great to be back, Natalia.
Thank you so much. And we are meeting here today in the middle of the pandemic. In Poland, it is about the fourth wave of it to start, to discuss something that is extremely important in international contracts in particular. And this is the force majeure. And Federico, as usual, first to start, can you please give us some sort of a definition of what we are talking about and why are we using the French term for that?
That's true. Yes, force majeure is defined as an event that is, in most jurisdictions, defined as unforeseeable and beyond the control of the parties that renders impossible for one or both, or if there are more parties to the contract, all parties to perform their contractual obligations. Mind you, it doesn't have to be all the parties involved. It could only be one that is prevented from performing its contractual obligations. And therefore, it is impossible for the contract to be performed, to reach the goals of the contract. And in this case, it is excused. So the big difference with other types of non-performance is that in the event of force majeure, you have an excuse. You are excused, you're relieved from the consequences of not performing your contractual obligations. This is an interesting clause. It is a clause that every trainee lawyer likes because it defines so many things. It's quite adventurous. It's like going through all sorts of possible scenarios that you would find in an action film. The typical clause, for those of you that are familiar with these clauses, it normally reads something like the parties would be excused from performing their contractual obligations in case of flood, earthquake, fire, terrorist attack, all sorts of tragic events. And usually these events, thank God, they're not so frequent. You can be insured against them, especially when it comes to natural events like earthquakes, fires, etc. But now with COVID-19, force majeure has been a clause that has been invoked quite a number of times, sometimes not in the right way, and sometimes wrongly. So
before you move forward and before we give some more detailed descriptions and some more cases, I would like to concentrate on some of these elements of the definition. Unforeseeable. Who is the one who is not able to foresee that this can happen? The parties or everyday people? What is the standard of being able to foresee?
We're getting complicated here. So first of all, as we said in the first episodes, it really depends on the jurisdiction. So back to square one, back to basics. Do we have a valid and enforceable agreement in place? Do we have a written agreement? Do we have a valid force majeure clause? Because yes, force majeure is defined in certain jurisdictions. You can find it in specific articles of civil codes, if we're referring to civil law jurisdictions like Poland, Italy, France, and you name it. But it cannot always be the case. I'm not, of course, familiar with all possible jurisdictions in the world, but I'm pretty sure that there will be some jurisdictions where force majeure is only briefly touched on. And in most cases, you will need to specify what you're talking about in a contract. So back to basics, have a properly written agreement, have a valid clause force majeure clause in the agreement, and make sure that you choose the right jurisdiction, because there could be conflicts of
And
law,
make sure
etc.
you choose the right lawyer to draft it for you and to ensure
Correct.
that it's definitely there, because this will be the part
Correct.
of the legal advice that is always necessary whenever such a situation arises. Federico, so now with COVID, and we are actually heading there, what do you think about it? What have you seen from your practice? Is COVID a case of force majeure that enables the parties to evoke it to help them alleviate their contractual obligations?
Yes and no. It depends. Typical lawyer's answer. And that goes back to your previous question, that is, what is the standard, and who defines what an event of force majeure is, who can tell whether it is predictable or not. Generally speaking, it is the paterfamilias, the normal, the average layperson that would have access to ordinary information. It is, however, true that in certain agreements that are highly specific in certain industries, where you have a high standard required for the parties to adhere to, so I don't know, the mining industry, the infrastructure contracts, and so on, they require a level of understanding of the circumstances that the average layperson does not have, or at least the average person is not required to have. So the standard is the standard applicable to that industry and to the average person working in that industry. So it could be that the threshold is a bit higher when it comes to that. So who defines that? Well, again, if you have a proper clause, it could be the parties, as long as you don't abuse of the definition. So as long as a force majeure event is still defined as an event which is unforeseeable and beyond the control of the parties, so there are these two elements, then it is the parties that define what it is. Otherwise, eventually, it's always a judge. So it's always a third person that doesn't really know your business, doesn't really know what the relationship between the parties is, and will have to read a contract that perhaps was written several years ago and try and interpret that. Hence, again, the importance of a properly drafted agreement. So back
From
to
what you were
COVID.
saying, it can depend on the actual part of the industry we're talking about. And I understand
Yeah,
that it will differ when we have something that was really very deeply touched by the COVID restrictions, things like hotel industry or
precisely.
restaurants, but it wouldn't be as applicable to individual entrepreneurs who could actually work from home even during lockdowns. Am I right?
Exactly. Absolutely, you're absolutely right, Natalia. Yes, it is exactly the case. First of all, in several standard clauses of force majeure, there is a broad definition that says that an event of force majeure is blah 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 blah, something that is beyond the control of the parties and unforeseeable by the parties, caused by natural events, blah, 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 and governmental actions. So, or authorities' decisions, judicial decisions, and stuff like that. So, in a way, COVID-19 can be interpreted as such. Not the pandemic per se, but the restrictions that have been imposed by authorities all over the world can indeed, and sometimes they, of course, fall into the definition of an event of force majeure, in that the local government took action to curb the spread of the pandemic, and therefore ordered companies not to operate or to shut down their facilities. And that is a governmental or an authority's decision, not the pandemic. The decision, the consequence of the pandemic is the decision taken by the government that requires you to shut down your office, to leave everybody home, and therefore you cannot operate. So it is a government's act that can fall into this definition. In other instances, as you mentioned, certain contractual obligations can indeed be performed from home. I mean, at least I, as a lawyer, I don't really go to court myself. I'm more of a consultant rather than somebody that appears in court, and I can carry out most of my tasks from home. So I cannot possibly invoke force majeure as a contractual as an excuse not to perform our contractual obligations. So yeah, there are industries that have been affected by these by these authorities' decisions, and they are excused. Others are not. Some jurisdictions, like Singapore, introduce specific legislation. For instance, Singapore introduced the temporary measures to curb COVID-19 that were temporary, as the name suggests, and were actually postponed. They were supposed to last, I think, for 1 year, and then they were postponed for another 6 months or something like that. And essentially, they were a package of measures, including financial measures, for instance, to alleviate the costs for rents of commercial spaces by companies operating in industries that had been shut down by the government. But they also included some more core legal measures, such as, well, first of all, the fact that funds would go directly to the tenants and not to the landlords. And secondly, that certain legal procedures could be followed, for instance, online. There is a specific provision in this statute, which is that AGMs in Singapore can be held online, which is something that perhaps certain companies included in their articles of association, but not all of them. So the government allowed for them to do so. But without specific interventions, specific norms introduced by governments, it is debatable whether COVID-19 in the first place can be considered an event of force majeure. I mean, we were discussing offline before that somebody predicted that there could be at least an epidemic of this sort, maybe not a pandemic. You, as a company, for instance, in the manufacturing industry, perhaps you are required by your industry standards to have stocks of products, to have backup plans, and so on. So sometimes, yes, maybe nobody could foresee COVID-19 per se, but somebody could foresee that there would be an epidemic, or in any case, you should have contingency plans anytime for whatever sort of event of this magnitude in place. So yeah, maybe again you cannot foresee COVID-19, but you can still foresee that something may go wrong, and therefore have backup plans in place. And most companies do not.
And talking about what sort of alleviation evoking of the force majeure can bring, so what sort of actions, of what sort of legal steps can an entrepreneur take when they made sure and had this contractual clause in their contracts, or if it was already covered by the jurisdiction that they were in?
No, typically it is something that is contractualized, using a horrible term, but usually it is something that is decided by the parties when they draft the clause. Normally there is a grace period. So depending on how structured the clause is, sometimes the clause states that you are excused to perform your obligations for, say, 1 month. I'm just inventing, it could be 1 month, 2 months, whatever. It depends also on the industry and how time dependent that industry is. So you have 1 month. Once the event of force majeure is over, you can resume the contract. If the event of force majeure persists and cannot be cured, which is precisely the case of COVID-19, because the pandemic has been going on for over a year and a half now, then the consequence could be, it is not necessarily the case, but one of the consequences could be that the contract is terminated by default. There could be other provisions, for instance, the clause could be a bit more structured, as I said, that say, well, okay, you are excused from performing material obligations, for instance, going to manufacturing, talking about very concrete things, but you're not excused from making online monetary transactions. That is, in the manufacturing industry, fair enough, a factory may be shut down, but online banking still works, so you cannot possibly claim that the bank is closed and you cannot perform a payment. There could also be provisions of the so-called duty to mitigate or duty of care. That is, yes, the situation is bad. Yes, it is unforeseeable. Yes, it is beyond your control. But what can you do and what do you have to do according to contractual obligations in order to try and mitigate what is going on? And that is also included in properly structured clauses. It is usually, to my knowledge, it is not something that is detailed that much in statutes in individual jurisdictions. So it is very important to think ahead and have it written in the clause in the contract.
I understand that once you put it into the contract, and especially in the international trade, it is so important because, again, you have two different jurisdictions. People can come from different legal backgrounds, have different legal customs and habits. That means that they might, once they sit together and negotiate their contract, they can put something really specific, tailor-made to their needs. But I do believe that having this sort of clause in your contract already in an event like we have now, so COVID, can push the parties to renegotiate their obligations, because nevertheless, whether they agree or not, they might face a legal action. So what might happen is that this action may happen because if they don't agree on the contract being renewed, being of this obligation being rephrased and adapted to the conditions, let us say, of COVID or the pandemic restrictions that were governing in almost the entire world, they would be facing a very expensive, very difficult legal action. What is your experience on that? Have you seen parties renegotiating their contracts based on the force
Yes.
majeure?
Yes, I have indeed. They thought it was force majeure. I don't think it was, but in any case, the concrete consequence was that they renegotiated the terms of the contract. It happened to me, it happened to a client of mine in the manufacturing industry that invoked force majeure deriving from COVID-19. Why? Because they're a manufacturing company, and as you all know, there has been a spike in the costs of raw materials and shipping costs.
And delays in supplies, right?
Oh yes, and delays. Now, the Suez Canal incident that occurred a few months ago, that could be defined as an event of force majeure. I mean, it doesn't really happen every day that a large cargo ship gets stuck in the Suez Canal. But increase in raw material prices and in shipping costs, I don't think it is something that is not foreseeable. It could be predicted by economic models. It is part of a cycle, and it is a consequence of what is going on. So, in my personal opinion, I'm not giving any legal advice to the viewers and listeners to this podcast, but generally speaking, I don't think this could be invoked, that this could be defined as a case of force majeure. In any case, the concrete action that this company took was to inform their customers and say, look, we all know, we all live on the same planet. We all know that prices have gone up, that there are delays, the shipping costs have gone up too. Let's renegotiate the terms. And it seems like it is working well, so they renegotiated such terms. But you mentioned, Natalia, one quick thing. You mentioned something related to culture, to different jurisdictions, etc. And that is very true. It happened to me a long, long time ago. I happened to work with Mongolian parties. That is, my clients were from Italy and other countries, but they worked in Mongolia in the construction industry also. And they did not take into account that in Mongolia, most construction sites, at the time at least, I don't know now, used to be closed due to the severe climate conditions between, say, November, December, and March. So they could not say, well, look, there is really an unexpected storm or cold weather in Mongolia and we cannot work. No, it is normal that people do not work in Mongolia in open air when it is perhaps minus 30. I experienced minus 30 in Mongolia in November. Now, if you work all day in a construction site, you cannot possibly resist. So construction sites have to be shut down for several months, not weeks. at least back in the days. Maybe they have found a solution for this. And that is not an event of force majeure, because it is something that is known to happen in a country like Mongolia in the wintertime. So indeed, the cross-cultural aspects are always fascinating and to be considered also for the legal consequences.
Having said that, we almost reached 20 minutes, and I think we need to close up. The topic is absolutely fascinating, and we'll think about expanding on it further. Thank you very much for watching and listening, and stay tuned to our next videos. Bye-bye.
Thank you, Natalia. Thank you all. Bye-bye.